Welcome to the next episode of Small Business Chat. We got a lot of stuff to talk about today. We got today, we Levi's, the famous denim company or pants or jackets, whatever they make. They are suing this Japan company because of the certain amount of stitching that they have on their clothing. Their name of their business is FullCount Co. and their Japan company, so that they're getting sued by big old Levi's for trademark infringement. So we got that going on today, and then we also Matt's going to lead this one. Also joins me today is Matt. Say hello to Matt. Say hello to Matt. Say hello to everyone, Matt.
Hello, Matt. Hey, man. Good morning. Good to see you.
Um,
Well, sort of. Good to hear you.
Good to hear you. And looks like also Reggie Bush is suing the NCAA,
Yeah, he is.
USC, Pac-12, the kitchen sink, everyone. He's just suing everyone now for apparently his name, image, likeness, or for when he starred on the Trojans. I mean, that's crazy. So we got a lot to talk about today. So let's just start off with the smaller one, Levi's. Get that one out of the way. Matt, I mean, you looked up the article just to brief ourselves again to start our day. But I mean, that's pretty close. I mean, I don't know what you think, but especially the one on the butt, the back pocket,
Yeah.
that is like pretty much almost the same.
Well, it's funny because you bring it up, but just so everyone knows what we're talking about. So Levi's, I guess, has sued this Japanese company, and it's we're talking about sort of trademark rights. But the nicer thing is it's sort of like almost it's not product packaging, it's really just design trademarks that we're talking about. And so what Levi's, at least the pictures they show in the article, they show that the company is allegedly knocking them off vis-a-vis their labels or their tags on their clothing, which are sort of, just to describe it for the audience, so they'll have like a leathery patch label on the back of the jeans. Everyone knows what I'm talking about, but then with sort of red images and or scripts on it. And then what Jacob was just sort of talking about is, the actual stitch patterns. Could you actually trademark a stitch pattern? And I think the answer is clearly yes. Whether or not you have to show acquired distinctiveness or not, that's for the experts. But before we even really go down that rabbit hole, just want to address something real quick. I sound like I'm one of the debate people, when in a debate, one of the politicians. I'm just going to talk about what I want to talk for a minute ago.
You have 3 minutes. Go.
Yeah, there you go. Start now, right? Because I'm going to go off on this NIL thing. But props out to Levi's. Like, one of the great American success stories. And I don't know their entire story. I just know they're one of those brands I think about when I think about like Coca-Cola, like turn of the century brands, that started like maybe I'm guessing maybe in the 1800s or something like that. And they're still around. And I'm sure over the years they've had venture capital come in. They've probably been purchased out. They're probably owned by like I don't even know, like Gap or Procter and Gamble or whoever the hell. But in my generation, you saw Guess jeans get big, and you've seen all these, different like Lucky brand get big. And again, they're probably all owned by the same company now. But it's just great to see a great old American brand out there, like Coca-Cola, still slinging it. And I understand, and one of the reasons and one of the critical things is number one, continue to create that product that people want. But then when someone sort of steps on your toes, you've got to put them into place. And here we are, right? Them going after this Japanese company. So what do you think about it?
I want to ask you a question. I'm also to answer yours. I think it's trademark infringement. I mean, but my biggest question is, I haven't looked it up specifically. If Levi has protection in the United States, as they obviously have, what happens if they didn't trademark their or enforce their trademark in Japan? Would that Japan company still be able to pull this off? Would they be able to not come through the other side with their business still intact after they got sued? What do you think?
Well, just in general, I mean, everyone should be aware that trademark rights, unlike like copyrights and all that sort of stuff, are country by country specific. So, do we know if they sued them here in the U.S. for importing the product in the U.S. or is this in Japan? I think it's in Japan, right?
All it says that they just sued full
A
count
Japanese company.
Japanese company. Yeah.
Okay. So if it's in the US, so the first thing that you have to look at is this a registered or an unregistered trademark for Levi Strauss? In other words, do they have the stitch pattern registered as a federally registered trademark here in the US?
And
And or let's just
how do you even trademark that, Matt? Like most trademark applications would you file? You're filing for a logo and or
Yeah.
a word. How do you trademark try to file a trademark for a stitch pattern?
Presumptively, I think it would be a design trademark, and you would have to show, um, yeah, it's either, I don't think it would fall into a product packaging, trademark, but I think you would actually do a design trademark. And specifically, the Patent and Trademark Office would probably require you to submit black and white images of how the design will actually appear on your products, in this case, clothing on the stitch patterns, and then actually produce samples, like specimens of it actually being matching up with that and such. And I wouldn't be surprised on this one if this would be determined to be, I don't know, this may be inherently distinctive. In other words, if you have just a stitch pattern that's completely unique, then they could actually say, okay, you don't get a merely descriptive refusal on it. But I also wouldn't be surprised if they have to, put some type of evidence forward that this is a famous stitch pattern. So when people see this, forgive me, it looks like and almost an M, or what I would do is like the old way you used to draw seagulls in a picture, where it's just sort of like an upside down W, and that's, I guess, Levi Strauss's signature. The challenge I would have with that one would be is the fact that this Japanese company, they actually do have an X. They continue their pattern down, so it X's, and I think they have less of an issue in that regard. But man, that when I looked at just the labels from a distance, from someone who has looked at conservatively, I'm sure over a million trademarks and had to make these, calls at some point in my career very quickly. To me, I think this is, if I just saw, first of all, I don't know if I would recognize the Levi Strauss or the Levi's, leather thing, because almost everyone does sort of a leather thing, but the leather and the red. But if they, get, experts or whoever it is, or survey evidence to say that, the average U.S. consumer actually recognizes that pattern, that, whatever with the saddle and then the red on it as Levi's, I think the Japanese company's got a problem with this, just because if they, assuming they can get over the hump, yes, this is a protected trademark, and for all I know, they have it registered for that pattern. That by the way, you can actually register color patterns and color palettes. I don't know if you know that, but you can. I want to say it's the Taco Cabana case from way back in the 80s or the 90s that said, like, in a restaurant, you could have. You remember the old? Do you ever go to an old McDonald's where they actually had red and yellow chairs?
Oh yeah, I used to love it when I was a kid.
Yeah, you can register color schemes as a trademark. So likewise, so it's potential that they could have registered this maybe as a color scheme, or they could have registered merely as, this is, hey, this is actually our label, and gotten the actual colors red and whatever you call it saddle on this. And if they did, assuming they have those trademark rights, I at least think that these things look very similar, in my opinion. And if I were sitting on that jury, I'd be already looking at that Japanese company going, mm-hmm, mm-hmm. What about you?
I agree with you, Matt, fully. And it's funny that that this isn't the first time they have sued Full Count. Before this, they've sued Full Count twice. Back in 2009 was the first time they sued them, and then 2018 they've also sued them, and they've come out the other side again both times and are still operating as a business. So
Yeah, it's wow. Okay, yeah, so it's a challenge. And by
yeah,
the way, this is when you talk about battles between mega brands and all that sort of stuff, and a lot of times I bash attorneys and all that sort of stuff. But a lot of times I'm very complimentary to them. This is why those mega brands like the Procters and Gambles, the Nikes, and all that sort of stuff of the world, have trademark lawyers that are probably billing in excess of $1,000 an hour, because at some juncture somebody had to have reviewed this, or they should have, for the company that's getting sued, and should have said, okay, we can do this. This is okay. I do think it's a challenge because, when you're trying to produce a product, you may or may not be thinking, does this other company have to imagine producing, a pair of shoes, and you design like some sort of cool stripe pattern on it. Like, and maybe even like the wave or whatever of I'm looking at my tennis shoes right now, like of how like the sole is attached, the rubber part of the sole is attached to the leather part of the sole. Like, you really do have to almost, sort of look very broadly at every little element of that and make sure that it's not something that you've copied off of somebody else's design or something like that, because I think that can be a real challenge. And I think that's proven to be a challenge in this case. And I think it's going to be a massive challenge. And I would, I think there was a scene in the movie, Liar, Liar with Jim Carrey. Did you ever see that movie?
oh, love that movie. Yep.
Yeah, and I think at some juncture he's in court and he's like, settle, 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 and he's clapping his hands.
Settle, settle. Yep.
And I'm like, yeah, and I'm just like, yeah, there you have it. Like, and most trademark cases, I think, rarely go all the way to jury or a judge verdict because usually when you get two good lawyers representing both sides, the one that's likely going to take the verdict against them is smart enough to know, and they can go to their client and say, listen, this is a business decision. They're right. And so I'm sure there's a lot more, and they'll take discovery and they'll go deep into this. But to be candid, just looking at it, if I knew that Levi's had trademark rights in this, and this was the case that I was served with, I'd be sitting down with my folks and saying, yeah, let's write a check and let's move away from moving this, or from producing these jeans.
Speaking of
That's
Liar Liar,
yeah.
I bet you laughed your ass off during that movie the entire time.
Oh, I loved it, man. That was a
Oh,
good movie.
yeah.
That's one of Jim Carrey's best that no one ever talks about. You know,
My favorite part of the movie is when he gets his car scratched. Remember that part?
no,
You scratched my car. No, it was there.
oh,
You liar.
yeah. My favorite, okay, my favorite part, and this is because it's not a very realistic lawyer movie, shall I say, but it's brilliantly done. Great comedy, and such. And when he goes, and now I will say this is fantastic. And I've taught my kids this, and I've taught, my wife this and all that sort of stuff. Always listen to my language very carefully because you may ask a question and I may lawyer you back and I may not actually answer your question, but you think I've answered your question. And so when his interaction with the judge, you remember when he kicks the crap out of himself in the bathroom, so hopefully he won't have to go forward with trial.
Yep.
And he's like, boom, boom, boom. And the judge is like, who did this? And he's like, a madman, Your Honor. Because I did it myself. A madman, Your Honor, at the end of his rope or whatever it is. It's like, so he's answering the question, but he's not answering the question. That's great lawyering right there, and such. And then at the end, the judge goes, well, do you think you can continue? And he's like, yes. He's like, because he
I
can't
love that
lie.
part.
I'm like, I love that. And it's funny because I have some very sad stories from trial every once in a while. And we've actually had to put trials off because one of our lead trial attorneys actually lost a parent literally during a cross-examination of a witness. We get a phone call, and oh my God, that was still one of the most horrific days of my life. Having to actually tell him that his father had suddenly passed. Sorry to suddenly take this in a really horrible direction. But, and the judge is actually, that was probably the one time that we've ever had a situation where the judge just looked at us and said, okay, this trial's over. We'll come back in a couple months. We'll get it back on schedule and all that sort of stuff. But I can't even tell you how many times that there has been those moments where you bring something to a judge's attention. They're like, oh, yeah, but can you still move on? And you're just like, yes, Your Honor, I guess the bleeding will stop eventually. You're like, okay.
Exactly.
Still, there's still a shark attached to your side. And you're just like, yep, let's go. Let's try this thing. I didn't need that, kidney. Anyways.
Awesome.
All right. So fun stuff. Good luck to Levi's. I don't think they're Levi. I think they dropped the Strauss. I think they're just Levi's now versus
All right,
this
so
Japanese company.
I'll ask you the question, Matt. Infringement or no?
Just in the limit of what we know. I mean, if I were sitting on the jury, I would probably vote, yeah, absolutely. To me, this is pretty close. Not so much on the stitch design, but definitely on the label design.
I mean,
Label design, I think, is problematic.
It's happened twice now that they got sued. So what's going to happen differently in this
Oh,
third?
that may come into evidence, by the way. Especially it depends if there was a settlement before, then it may not come into evidence. But a really, really good attorney can bring that up subtly to say, there's sort of a repeat offenders, and there's a evidentiary rule about prior bad acts and all that sort of stuff that sometimes it doesn't come in. But if you know how to get it in for certain things, that's to me inflammatory as a juror, as a potential juror, and as an attorney. That like, okay, so you've already been put on notice once of these infractions. You need to be hyper vigilant vis-a-vis our stuff. And if you're not being hyper vigilant, you look like a repeat offender. And we're going to ding you hard with possibly punitive damages as well. In general, again, don't know the exact story behind this. I'm just relying on what you're telling me.
Gotcha. And so I guess that's going to be a yes on the infringement. I also say
Yeah.
yes, infringement as well. It's pretty close. They got the red tag. They got the stitching. I mean, what are they trying to do here? So why can't they just make crap?
So drawing this just a little bit, just before we move on to the NIL, because I'm going to be heated on this one. Just for our small business customers, what can they take from this? The thing that I would just simply say is just know that unfortunately in this day and age, be particularly careful if you're creating a brand. It doesn't matter what it is, if it's shoes, clothing, services, whatnot. Be very cautious if you look at somebody else for inspiration. I mean, just last podcast, we were talking about the song, Flowers versus that other Bruno Mars song that had something to do with flowers. And so maybe Miley Cyrus,
If I was your man, yeah.
I don't know. Yeah, yeah, If I Was Your Man, that's the name of the song. Okay. I should have brought you flowers, but the song says If I Was Your Man. Okay,
Yep.
anyways. All right, well, thank you. But so, you have to be careful in this day and age because looking at another brand, you may subconsciously actually adopt something from that other brand, and then it leads to something. So, for instance, maybe this Japanese company didn't intend to do it, but they're just like, hey, that's really cool. Like maybe one of their designers down the road like grew up wearing Levi's because in Japan during the 80s they're all about wearing American stuff. They're like 10 years behind us, right? And such. And so maybe one of their designers subconsciously put this thing in. And so for our small business customers, just be very careful if you actually, the best example I can give for you, and this goes back to the flowers thing. There's a time, and not a lot of people know this, but I have a lot of musicians in my family, and I was playing around at a time, I can't remember, and so I wrote an entire album, to possibly record and all that sort of stuff myself, and but then one of the songs I was always thinking about, 'cause I'm a big Jimmy Buffett fan, God rest his soul, great man, and I actually wrote an entire song called Rum Runner because I was like, okay, that's cool because he's got Margaritaville. I'm gonna make this sort of fun, sort of a country-ish type thing and all that sort of stuff. And as I was playing it through and I was recording the backtracks and all that sort of stuff, I basically was like, give me that. And then I'm like, oh my God, this is a goddamn Jimmy Buffett song. I literally copied the melody and I didn't even knew, I completely did it subconsciously. And then I was like, and
Really?
that submarine, my entire, like, I was like, holy crap, well, I'm not going to come out with this thing. Cause then I look back at one of the other songs. I'm like, well, that's Son of a Sailor. Holy God dang it. And I'm like, I just made different lyrics to the Jimmy Buffett song. But in this day and age, that will get you sued. And you got to be really, really careful about that. So for small
What
business owners, just be careful if you're looking at something else for your inspiration, because it could be protected by a trademark.
question, Matt? With
Yo,
you being, or just like Levi or even bigger companies, or same amount of how big they are. What precautions does each company take to find infringement? Do they just have lawyers 24/7 just looking for it, or is it just? I mean, how do they monitor it? How do
yes.
lawyers look for this type of thing?
Yeah, so I mean, great question. Thank you. So the old school way, and I believe the old school way is probably still used by your, premium brands, such as, like, the Googles, the Nikes of the world, and all that sort of stuff. Um, you actually contract with usually independent services, and I can't remember the names of some of the big ones because, our customers tend not to use them, and I've always been in a sort of a different, line or something like that. But you contract and they produce these huge search reports every month. And, again, I think they're overkill. But it used to be that, they would, in the olden days, you would get, delivered to your, law office, a 500-page search report for, let's just say, this is an example, I'm just making this up as a hypothetical, Coca-Cola. So then they would go through, the search report would, go through all the trademarks that have been filed in the last month in the US and probably around the world, that contain Coca-Cola or anything that's phonetically similar or something like that. And then even go out into what we call common law sources, any internet domain names who are registered, anyone that's running commercials, anyone who opened a brick and mortar store that we picked up on through your articles. And an attorney will read this entire report and then flag anything that they think is too close, forward a status report to the probably in-house counsel, and the in-house counsel will say, yes, send them a cease and desist. No, don't send them a cease and desist. So when you're dealing with these mega brands, understand they have big law firms that are paid to basically look for infringement just like that. Today, probably a little bit more electronic. And to be candid with you, with Google alerts and a lot of things that you can actually do to protect your own brand, it's probably more in real time, but you still have attorneys that are paid to make sure that their customers' brands aren't infringed on. And it's a good thing. To believe it or not, for the most part, it's a good thing. Some people overreach with it, but it's a good thing because I mean, if I spend $1 billion building up my brand, like, Google or Coca-Cola or whatnot, it's my brand and you don't have the right to use it, and nor should you, because I'm a very, I believe in strong brands, because that way I know that Coke tastes great. And no offense, I don't like the Pepsi. I want the Coca-Cola, but I don't want to pick up a Coca-Cola that's not made from those great people down in Atlanta. By the way, Coke Zero because it's zero sugar. Oh, one other thing, Coca-Cola, if you're listening, which you're probably not, kill the aspartame. Okay, seriously, go to sucralose. Just saying. All right, go ahead.
Yes, causes cancer. Causes cancer.
Yeah, well, the aspartame, no, it's causing I can't. Oh, memory loss. Yeah, that.
Well, there you go. Yes,
Sorry.
let's just stop.
I think that's what it's been linked to now. Memory loss and something else.
Okay. Well, Matt, I think it's time to turn on over to the bigger news here. Mr. Reggie Bush
Yeah, right.
filed a lawsuit against USC, the Pac-12, and NCAA seeking compensation for his name, image, and likeness while he starred for.
Pay him. Sorry, go ahead. Keep going. I'm sorry, I'm just interrupting him. Pay him. You know where I'm
exactly. In the filing, Bush's legal team points out that all the three entities that he earned significant compensation for on the back of Bush's effort among the revenue streams that identify are television contracts, merchandise sales, and media rights that all tie back to Bush's career. The article says, like most athletes at the time, Bush did not receive any direct compensation from the university or NCAA for his play. This is from the lawyer. This case is not just about seeking justice for Reggie Bush. It's about setting a precedent for the fair treatment of college athletes. Our goal is to rectify this injustice and pave the way for a system where the athletes are rightfully recognized, compensated, and treated fairly for their contributions. I mean, Matt, we went over this in the last podcast over the NCAA and that them not being able to create an NCAA football game because of trademark rights with people's names. So, Matt, take it away. Reggie Bush is leading the way for this one. What do you think?
Hey, man. Okay, I'm done. That's all I got. No, I will say on an aside, just by mere coincidence, Fox Big Saturday was live from Ohio Stadium at Ohio State University, and I was a stone's throw away from Reggie's great teammate Matt Leonard for like about 20 or 30 minutes the other day, just this past Saturday, and he still looks great and all that sort of stuff. Looks like he could still strap on the pads and go play, but one of the greatest duos in college football history, Matt Leonard and Reggie Bush. Again, I wasn't a big fan of USC back in the day because I still love my Florida State and Miami teams. But you couldn't deny the sheer raw talent up and down that roster, and one of the greatest college football teams of all time, and with Reggie Bush and Matt Leonard. But just away on a very brief aside, they played at Notre Dame, and it was back in the day when Notre Dame was really, really good as well. And on that team, I'll get to the NIL real quick, but Reggie Bush was so stunningly dynamic. And they knew they were going to be playing at a night game at Notre Dame. And to try to slow him down because he was so fast, the rumor was, and I have friends like that know people that played in the game. They're like, they didn't cut the grass at Notre Dame for like a week and a half to 2 weeks before USC came, and they said literally the grass was like 8 inches like deep, and then they wet it down the day before, so it was like wet and muddy and stuff to try to slow Reggie Bush down. They were still able to win on a last second Matt Leonard quarterback sneak that they weren't expecting or something like that. But anyways, yeah, so back to the NIL thing. Sorry. As we're all aware, this started a couple years ago because, and again, I'll use this for all you business owners out there. I think this is just once again one of the largest examples you can see of a business that is refusing to evolve, and then the evolution is taking place outside of the business, and they're now getting dragged behind it, like they're getting dragged behind like a car with a rope or something like that, and they're kicking and screaming about it. But NCAA and like the other people, well, they bitch and moan about now having to pay players and all that sort of stuff. You've had the opportunity for years to control this thing. And finally, legislature, starting with props out to the California legislature, state legislature, started this and said, hey, you can no longer declare someone academically ineligible because they get NIL money because everyone else has got their hands in the pot, in that pot. The university presidents are living in $1 million homes, college football coaches living in $12 million homes, making all this money, and you ain't paying the players. Okay, so everyone else is benefit. Oh, ABC's making tons of money, ESPN, Fox, everyone making money, but the players. And so once again, to remind everyone, you all have the ability to have gotten out in front of this. You need to look as a business person, you need to see where your marketplace is going and keep out in front of it as opposed to reacting and then started like saying like, whoa, well, we're just trying to figure this all out and NIL is crazy and all that sort of stuff. It's crazy because you didn't mind your store and you could have been minding your store, NCAA, Pac-12 and such. But again, props out to the California legislature, which is where many of the teams from the Pac-12 used to be. They sort of started to figure this out. So back to Reggie Bush's case, this all started with the Ed O'Bannon. And we remember good old Ed from UCLA, if I recall correctly, saw himself in a video game many years ago. And he's just like, why didn't I get paid for this? That's my name, image, and likeness. So taking even a further step back, you folks all have a right to your own name, image, and likeness. No one can put your face on a pasta bottle without your consent, without giving you a license for it. Just like I couldn't
put pasta now.
Pasta bottle, pasta bottle. I'm thinking like Paul Newman. You remember that actor, Paul Newman?
Yep, Paul Newman.
Like I couldn't like put like Matt Swires' pasta sauce out there with Paul Newman's face on it because he has a right, or his estate at this juncture to the great actor has a right to that. Same with like Michael Jordan. I can't start Michael Jordan's Nissan without his consent because why? There's that, you heard of Michael Jordan, right?
Yeah.
Basketball player.
Mm.
No.
I think everyone does.
Yeah. Yeah, ring a bell. Okay, rings a bell. Okay, yeah. He played at UNC. Decent guy. I don't know what happened to him after that. Anyways, but so you have a right to your, name, image, and likeness, and anyone who uses it has to pay you. Well, the way the NCAA kept these guys in servitude for however many years, in my opinion, was they said, well, but you're academically ineligible if you get any money. Well, the California legislature said, yeah, you can't do that anymore. And then everyone had to fall into step. And so the chaos, which is currently created by the NIL, is because the universities and the NCAA haven't modernized. Dude, modernize your damn business models. Pay the kids. So, but now going back in time, Reggie's looking at all this going, well, how many times was my running down the sidelines used for ABC Sports to advertise for the next game? I'm gonna give you the most famous one I can think of, and he won't do it because he currently works for them. But man, Desmond Howard, do you know who I'm talking about? Desmond?
No, I don't. No.
Okay. Heisman Trophy winner for the University of Michigan. And again, a little bit of vomit in my throat because I'm an Ohio State fan because my son goes there now. But I'll talk about Big Blue because hey, it's a quality program. One of the nation's blue bloods, and so they do a great job. But when Desmond was at the University of Michigan, I believe it was when first of all, his senior season was just a breakout, amazing season. One of the greatest, like most electrifying college athletes of all time, Desmond Howard. And at one point, it was later in the season where he was just blowing away, like, the straw polls or who's going to win the Heisman Trophy. I think he takes a kickoff all the way back or whatever. I know he scores a touchdown. And in the end zone, right when the camera's coming up to him and all that sort of stuff, he throws up the Heisman pose. He's one of the only people that's ever actually done that. And it's iconic. It was like Babe Ruth going back in the day. It's like Babe Ruth calling a shot that they actually don't have video of, but they just talk about it and such. He literally throws up the Heisman. Do you know that they've used that clip of video to basically they used that for years to basically advertise the big game that's coming up this
for it?
Yeah. I don't think so because again, they didn't have to, right? Because he was a college athlete at the time. What Reggie Bush is now saying is this, hey man, you're using like my name, image, and likeness to promote the NCAA and all that sort of stuff. Are y'all getting paid for that? And they're like, oh yeah, we made hundreds of millions, maybe billions of dollars off that. He's like, that's funny. I didn't get my check because it was me. So I get it, and I think it's a slam dunk case for him. And I absolutely agree. And it's time that these places, and going back in time, the answer is yeah, there's going to be some comeuppance for them because once again. 1970s, no big deal. The television contracts really aren't anything and all that sort of stuff. But then there was a good 20, 25-year stretch that they just haven't been sharing the love. And now the athletes have the law on their side. And I think all of these athletes, they just need to go back and look at the promos for, what ESPN and ABC, et cetera, have been running for years. And for those kids that were in those, and there was no grant of media rights in their scholarships at that time, I'm sure today that's being remedied as we speak. I had an opportunity to look for someone. I got an opportunity to review their scholarship opportunity recently from, we'll just say, a major SEC program. And I can't remember if they had a grant of media rights in there or not. I don't remember seeing it now that I think about it. But I'm a little bit surprised they did not have it in there. But anyways, that, Reggie should win because, hey, question, did you use my name, image, or likeness in your commercials? Yes. Question two, did you get paid for it? Yes. Question three, how much did I get paid for it? None. Okay, you can't use it. It's illegal. Where's the question? Pay
Gotcha.
him.
So do you think
This is
Reggie
another one. Here, we'll go back to the original thing. Jim Carrey, saddle, 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 saddle.
Do you
You
think
know,
Reggie Bush
so
is going to win all this that he's trying to pull off?
absolutely, 100%. And the reality is what the NCAA should do now is, and the Pac-12 and USC, they need to have a global settlement with people that they've used, their name, image, and likeness for years. So I mean, and for all I know, it's coming. And so I'm not in on their conversations and such. But what would be better if they just put aside, a fund. They've already, this is what you do when you've wronged people and you now know that you're wrong. Again, all this is my opinion. You basically put aside a fund of money and just say, okay, and then from that fund of money, you start paying people back. No, I'm just trying to think, like, I mean, theoretically, I'll tell you one of the other college players that really I can remember. And I don't know exactly if this guy can get it, but do you ever see the old it used to be called The Game, and it was Cal Stanford, and they used to show the clip of I think it was the Cal player, and they did a couple of laterals, but they literally at the end they take basically the I think Stanford goes up by like 5 points or something with like a second left, and they still have to kick it off. And the Stanford band screws up, and they start marching across the field because they think it's over. Dude is running through the Stanford band and scores a touchdown, the winning touchdown. Half the Stanford guys can't actually get to him because the band was blocking them. And some weird whatever back in the day, it's touchdown. It's over. It's one of the greatest moments in sports, in college sports history. And they don't really show that one anymore because it's just such an old clip. Have you ever seen that clip? Do you know what I'm talking about?
No, I don't think I've seen that clip before.
But so as the dude is like running into the end zone, he like just trucks a trombone player. I mean, it's
Oh, wait a
hysterical.
minute. Wait a minute. I think I have seen that.
Yeah, like I think he
It does
bends
ring
up
a
his
bell.
trombone and stuff. I'm like, so I wonder if like the dude that actually ran the ball back and the trombone player could now go back to the NCAA and be like, dude, you've shown this clip over like 10 million times now. We want $1 a piece, for every time you've shown that. But that's the name, image, and likeness. But again, I think the difference would just simply be is I don't know the names of those two kids who were involved in that collision. So I just think of it because it's funny because it's whatever. But when you show Reggie Bush running down the sideline at Notre Dame, or when any numerous touchdowns for USC, because he was stunningly good athlete and good player. Had a pretty good pro career, if I recall correctly. For some reason I think it was short, but I'm pretty sure he was running for New Orleans for many years. But and you see like Desmond Howard throwing up that whatnot. For, like the recent plays that you don't see as much, but it's I think one of the greatest plays of all time would be the kick six, Auburn versus Alabama. But again, if you're using this to promote your stuff, you've got to realistically say, do we have a grant of rights at that juncture? No. Okay, I have to, if I'm showing names on jerseys and people know who this is, I think they have an obligation to actually pay them. Because again, it's promoting your product, you know. Sorry, but that's the way it is. How'd I
Awesome.
do?
No, you did really great. I think we're in support of Reggie Bush now.
Oh yeah, I mean, and I think he got his Heisman Trophy back because I've been watching the Heisman House, and they de-thaw him in a great commercial and all that sort of stuff. I thought they could have done a little bit funnier things of how things have changed and such, but it's a good commercial. But once again, bringing this back, okay, so everyone knows, the two things that I think small business owners should actually take from this NIL rant, what do you think, whatever, anyways, would be is number one, you have a right to your name, image, and likeness, just like a trademark. So we talked previously about the Levi's and such. Can you trademark a stitch pattern? Can you do different designs and all that sort of stuff? Yes, and you have to be careful about not adopting other people's, especially if you've use them for your inspiration. Be very cautious when inspiration turns into copying or it's just too close. But then the next thing I would take from this would be with the Reggie Bush NCAA Pac-12, USC type thing. And this is for all the universities and NCAAs is get out in front of where your business is going and don't stay stagnant. Because eventually what happens if you're trying to just stay status quo, they eventually had a legislator that just basically said, you can't stay status quo anymore, man. And then now they're sort of playing almost the victim, like, oh, it's all out of control and NIL and they're lobbying Congress and stuff. Dude, they should have been doing that a decade ago. And they made a lot of money off of these kids. So don't feel bad when Reggie Bush comes back and says, hey, pay me. Because this has been 20 years, 25, 30 years of them putting a lot of money in their pockets. And just think about where the execs at, ESPN and ABC live and think about their houses and they're just dream about how big their house. I guarantee you they're not living in 1,200 square foot apartments, in some shoddy neighborhood. These people have all made a tremendous amount of money off of this. And it's time through trademark laws and otherwise that these other people get compensated. But get out in front of these things because there's only chaos because they failed to see where their business model was going and or they shoved their head in the sand like an ostrich. Don't in your business ever afford the luxury of shoving your head in the sand like an ostrich. Keep it up, look forward, be perspective, and change as you need to. And then you become Levi's, who basically, and I don't know what changes they've made to say, but they're still here after 100 and something years. Okay, fantastic job on their part. NCAA, get your jobs out, and again, I don't understand why the NCAA hasn't basically just come out and said, what we're going to do? We're going to be basically the lead union for the players. There's their opportunity right there and actually be the advocates for the players that they always say that they are in all these commercials, as opposed to trying to take away their eligibility and prosecute them at every, turn when a player takes a bus ticket for his for her grandmother's funeral. Meanwhile, it's $43 and he couldn't afford it. All the while the coach is living in a $12 million mansion arguing why the players shouldn't get paid. Please, come on. And the second thing would just simply be is just remember you can basically, trademark, you are entitled to those name, image, and likeness. So that is yours. No one can take that away from you. If someone rebroadcasts you, puts your face on something, you're entitled to compensation for that. So again, modernize, see where it's going, keep up with things, and keep in front of them, most importantly, if you can in your business. And secondly, name, image, likeness is real, and you're entitled to your own. Good deal?
Good deal. I think we should make the thumbnail an ostrich. What do you think?
An ostrich? Yeah, that'd be cute. I love that one.
Awesome. Well, so we agreed on Levi's that there's an infringement there. So we'll see what happens with that.
So what do you think about Reggie? Let me ask you after that soliloquy on my part.
I 100% agree with you because just these huge companies that are making millions and billions off of people and not giving people their fair share is a tragedy to people. And I think that you should give people the credit where credit is due. Matt, I think you would love if you sit down and watch Netflix. I don't know if you ever do, but watch Better Call Saul. There's actually, I think it's like in the third or fourth season. You probably won't remember this. So I won't spoil it for you. If you are watching Better Call Saul on Netflix right now, stop watching or listening. But there's this one section of where the lawyer, it's because it's all about lawyers and attorneys in this show. It's amazing. And there's this one part where the lawyer was trying to argue a case about how one of this really huge bank, and it's a not a realistic bank. They made it for just for the show, but in the show, this bank is a very rich bank, and their logo was actually somebody created this logo a very long time ago for the bank, and they were paid since it was a long time ago, paid like maybe $100-$200 for it. And ended up being their staple for their bank and their likeness for their bank. And the lady, the lawyer actually contacted to try to sue the bank and try to get the lady to basically file a lawsuit against the bank so that they would pay her more money for the actual logo itself. I think they actually won it too somehow in the show. Again, it's all not realistic, but yeah, it's kind of reminded me of this. But
and to your question, by the way, do I have Netflix? No, I lost it in the divorce. So sorry.
You can get it back again.
Netflix will sell me another subscription. They're like, here,
$25 a month. It's worth it. Sorry,
$25 a month.
Yeah, yeah. Well, I mean, I kind of go a little bit all out. I buy the extra 4K Ultra edition, so
Look at
because I
you.
have
Air flip.
a very expensive OLED TV. Anyways, so that will do it for today. Again, Levi's. So we'll see what happens with that. And Reggie Bush, I hope the best for you, bud. Hope that you get your fair share. All right, so that does it. Thank you for anybody that's listening. Again, every episode is sponsored by the Trademark Company. So go on over there. It's always in the link in the description. If you have any questions, reach a filing expert or trademark expert on that website. So thank you for all for listening and have a great day.